try to keep my presentation simple, and I'll try to explain this concept of anti-dumping in a commercial manner. Yeah, so I will be talking about what actually dumping is, the concept, the rights for the domestic industry. Then what are the risks for exporters? Either you are exporting from your home country or you are facing exports from outside. Yeah, hello. I think it's better standing here. And how can an exporter transform risk into the opportunity? So I'll try to explain all these basic concepts in a very simple manner. When we talk about dumping, actually, it is a practice of price discrimination. When an exporter is selling a product at a higher price in its export market or in the domestic market, and exporting the same product to another country at a lower price, the difference of the price is actually the dumping. For example, I'm based in China and I'm selling this mic at a price of $100, and I'm exporting the same mic to UAE at a price of $90. So difference of $10 price is dumping, which is unfair trade practice. And the WTO laws allows imposition of anti-dumping duties in such kind of a scenario. The second scenario is if you are selling your product to the export market at less than your cost. This again is a very, very common scenario. Generally what we have seen in different countries, in different companies, that when you are producing at a particular capacity utilization, say 60 to 70%, and you're selling in the domestic market and making money, in order to increase your capacity utilization, you are ready to sell the product at just a contribution margin, which means that if you see what is the differential cost of producing one additional unit, and if you think that your sale price can cover the price of your additional cost for the production of additional unit, which is called contribution margin, you just feel easy to export at that price, and that price actually comes under the ambit of dumping because you are selling at less than your cost to another country. What is the risk for the domestic industry? If I am a producer of a product like this mic in UAE, what is the risk for me for inward dumping? If the dumping is taking place from, say, China to UAE, this could be the risk for me. If cheap or dumped imports are coming into UAE from China, what would be the adverse effect, which is called injury to the domestic industry? I'll lose my sales volume in UAE. People would like to buy cheap or dumped mics from China. So the dumped imports or the cheap imports from China will take my market share in the UAE. Similarly, my inventories will go up. I will not be able to recover my cost of production. I would not be able to increase my price in the domestic market because people will buy more of a dumped product, which is cheap, available in UAE. My capacity utilization will go down. My cost of production will go up because if I'm not able to produce at a reasonable capacity, my cost per unit will go up. Likewise, the productivity will go down. My profitability will go down. Ultimately, the cash flows, return on investment, these are all adverse or negative factors which I will have to face because of dumping. Now, what are the rights available for the domestic industry? What is the way out for me? What is the remedy for me to overcome this kind of dumping and injury? Being a domestic producer in UAE, I can file an anti-dumping application with the Ministry of Economy, which is the investigating authority in UAE, and filing an application alleging that dumping is taking place from country A or country B into UAE, and due to that dumping, I'm losing my market share. I'm not able to fetch a reasonable price. I'm not able to get the profit margin which I intend to. So this is the right which is available for the domestic producer to overcome the injury being faced due to dumping. And what would be the benefit of using this right? If I file an application, with the authority, and if the anti-dumping duties are imposed against dumping into UAE, these are the benefits I'm going to enjoy. These are all the same injury factors, but in the reverse order. My landed cost of dumped imports will go up, and I will get a better market price in the local market. So my volume of sales will go up, my market share will increase. Likewise, my inventories will go down, my cost of production will reduce because I'll be able to sell more than before. I'll be able to get more capacity utilization now. So these are the benefits of getting the duties imposed. Now, what is the risk for an exporter? If I am an exporter, if I am a large-scale producer in UAE and I'm exporting to India, China, and many other countries, what kind of risk is for me? The risk is that my exports could face anti-dumping investigation from other authorities, from other countries. And if such thing happens, if I face anti-dumping duty from other exporting countries, the risk would be I will lose my market share of exports. So what I'm going to do? How can I mitigate that risk? I need to assess that which markets are very important for me. Then I do not need to wait for the authorities in the exporting country to initiate anti-dumping investigation against me. I have to be proactive rather than reactive. Yesterday, Ahmed, in his discussion, pointed out that proactive approach is always better than the reactive approach. So the proactive approach in this scenario is I need to prepare myself well before any adverse impact is faced for my business, which means that if any anti-dumping investigation is initiated by other authorities, I have to prepare myself. And what I can do for that, I need to prepare myself keeping in view the questionnaires of those authorities. If my major exports are to India, I need to know what kind of exporters questionnaire will be sent to me by Indian authority in case anti-dumping investigation is initiated against me. And I have to prepare my data, my analysis, well before any action is taken by Indian authority. And this is what we have been doing for our clients, not only in Pakistan, in different jurisdictions. And companies who are very proactive, companies whose business are relying major on exports, they always do the same. This is just a hypothetical example of how you can convert the risk into opportunity. How can, as an exporter, I can convert my risk of getting the duties imposed into opportunity? Just look at the example. If country A, there were two exporters, company 1 and company 2. One of the company faces 8% dumping duty. The other, they got 0. Country B faces duty of 10%. Country C faces a duty of 25%. So as a result of this investigation, company 2 within the country A benefits the most. So this means that the company B within the country A participated very well during the course of the investigation, and they have been able to present their data information in a very organized manner to the authority. And if they get the minimum duty or the 0 duty, obviously they will take more market share in their exports. They will fetch up the market share of company 1 in country A. Even they will take the market share of country B and country C exporters into that destination. So this is how you convert your risk into opportunity. This is just an example of what is going on in the UAE market now. Even exports from UAE are subject to anti-dumping investigations from various authorities. Even you can see that India initiated 17 measures against UAE, imposed duties on 9. Pakistan initiated 3, imposed duty on 1. United States initiated 7 investigation, they imposed duty on 4. And these are the sector-wise analysis or the breakup of these investigations. What is the law in UAE for anti-dumping? It is the federal decree in the UAE. Generally, it is actually the GCC common law which is used for anti-dumping investigation in the whole region of GCC, which is the federal law number 7 of 2005. That is the primary legislation with respect to trade remedies. But UAE in 2017, they introduced a new law, which is a new trade remedy law in 2017, With this new law in place, now the UAE government can initiate anti-dumping investigation specifically for the domestic industry based in UAE. Because previously they have to initiate investigations for the GCC as a whole. So GCC authority is based in Riyadh, and all investigations have been based on Riyadh on the basis of GCC level. Now with this new law, investigation can be done specifically solely for UAE producers as well. As I said earlier, the Department of Anti-Dumping within the UAE Ministry of Economy is the authority that conducts trade defense investigation, and they impose trade remedy measures. Recently, the Ministry of Economy has decided and they have imposed anti-dumping duties in 3 investigations in 2020. This shows that the trend of anti-dumping is increasing in UAE market. At one side, they are facing investigations from different countries on their exports. On the other hand, to combat inward dumping into UAE, now the UAE government is imposing duty. They recently imposed duty on uncoated paper and paperboard at a rate of 24 to 31%. Now you can well imagine if a duty is imposed above the custom duty at a rate of 31 or 24%, obviously the imports will be completely stopped and the domestic industry in that country will flourish. Likewise, they have imposed one duty against imports of hydraulic cement from Iran. Another case in 2020 was certain ceramic tiles from China and against India. Thank you very much. If you have any questions, I would be pleased to answer. Yes, please.
Thank you, Mr. Khan, for such an insightful presentation. I have just one question. Yeah, so differential pricing as such is a reality in businesses. And so, in fact, it is if I may say that, it is even used as a business strategy. So how do we reconcile this differential pricing being a reality and anti-dumping? Where is the dividing line? When does one cross the line?
This is a very good question. Actually, what I have observed during the last 2 decades, I have been dealing with anti-dumping investigation for the last 20 years now. This differential pricing is actually is a fact. And that is why if you take out the statistics, in most of the anti-dumping investigations, once the investigation is initiated, you get some anti-dumping duty imposed, or at least you get some dumping margin calculated when you get the data from exporters. Because it's a reality. Companies, what they do, they make money from their domestic market. Because for the domestic market sales, you already have a custom duty protection available. So you are selling at a local market at a good price and making money. And when you want to export is always very, very competitive. So for exports, you have to reduce price generally so that you can penetrate in that export market. And once you reduce price, you get into dumping. So you get into the trap of dumping whenever you try to export more. It is a reality. I have seen in 95% of cases I have dealt with, dumping takes place intentionally or unintentionally. Even for the companies we work, and we get the anti-dumping duties imposed for their protection. When they start exporting to other countries, they do the dumping as well. So it's a reality. It's a reality, and that is the reason why it is called an unfair trade practice, and the WTO law provides that you can impose duty. Actually, the model law in this case is the WTO legal text, which is the anti-dumping agreement of the WTO. And all member countries of the WTO, they have to have their domestic legislation. And Pakistan, India, they are very aggressive user of anti-dumping measures.
Thank you.
Thank you. Yes.
Yeah. What I wanted to ask was, of course, when you speak of anti-dumping being an unfair trade practice, so that has, of course, lots of parallels and even overlaps with competition law, antitrust and competition law. So just to take the example of India, for instance, you gave one definition of anti-dumping being as exporting into a new market. at below cost or below production price, which is also how it is also the basis of the calculation for predatory pricing, for instance, under the competition law in India. But one of the additional factors for an anti-competitive act is appreciable adverse impact on the market. And for predatory pricing, for example, to give an example of the Jio case in India, they said, well, this is severely undercutting the market, and specifically with the purpose of gaining market share. But because it's a new player, its market share, its existing market share is so low, it can't have an AEC in that sense. So is there a sort of how do you think that countries have to, or the law has to reconcile these two overlapping yet parallel acts of both unfair trade practices, where you might escape one but then get caught in the other net?
Yeah. Good question. Actually, predating prices in the competition law is you are charging less price in your local market, and then you are distorting the competition. You are not letting others to get into the market, or you are trying to just eliminate the shorter players. In anti-dumping investigation, the price you're not reducing your price in the local market. You are reducing your price in the other market, export market. So these are two different things. Predatory pricing is reducing price in your own domestic market. But in anti-dumping, you are actually selling at a higher price in your domestic market, in your country, but you are selling at a cheap price, low price to the other market. So these are two different things. But there is a very strong correlation. How? Once the anti-dumping duties are imposed, I showed you a few examples. Duties could be imposed up to the rate of 60%. Or there are cases where US imposed duty against China of 200%. So just imagine if 50-60% duties are imposed, and you are a producer in India. Once the duties are imposed at a 50 or 60%, you will have no imports at all. This means the domestic producers, they get more dominant. And once they get more dominant, there is a more likely chance of abuse of dominant position. And if you are only one producer, you will get monopoly power, more strong monopoly power. If there are two producers of that product, it will be an oligopoly. So there is a strong correlation between anti-dumping law and the competition law. There is a perspective to it, yes, for sure. Yes, please.
Hi, I'm Rajesh here. I have lived in South Korea for 5 years, and what you're talking about local prices being lower, I feel it's other way around. The prices are never lower in the local market. It's because of the taxes. The prices go up.
But sir, I said prices are higher in the local market. I didn't say lower in the local market.
So when they export the goods to other countries,
exports are low price, but the domestic price is always higher. That is dumping.
Okay.
Yeah. So domestic price is $100, but you are exporting to other country at $90. So the $10 difference is dumping margin.
No, that difference can be taxes also. Because when you export, the local taxes are waived off.
Good question. The dumping margin, actually, I try to keep my presentation simple. When you calculate dumping margin, that is calculated on X factory level.
Okay.
So all taxes and costs are reduced.
Okay.
So you have to calculate normal value, your domestic price at X factory level, and you have to calculate export price at the X factory level. So all taxes are eliminated.
But then would the cost of labor also be not calculated in that? Because when they have a surplus production, the cost of production goes down.
The cost of labor is part of your cost to make and sell, which is a profit and loss item. So it will be reported, obviously, it will be there. But any additional cost outside your gate, transportation, your terminal handling charges, your ocean freight, your inland freight, taxes, that is reduced.
Will not be there other factors like they have to make a commitment of meeting the sales, and for that they would dump the goods in another country just to show the performance in their banks. Would not be that point again?
So it's a two-way sword. You want to show good performance with the banks and you start doing dumping, it is not a justification.
Okay. And will this dumping be used as a political influence in other countries? Can it be used?
Very much.
Okay.
It is currently used, yes.
We'll be taking one more question.
Thank you. I'm talking of a scenario post-COVID-19 many countries have insulated their economies in respect of this kind of imports as well as exports. How did this COVID-19 situation had an impact on these anti-dumping measures on an international level?
Sir, it has a great impact. The interview I had with Bharti, she asked me this question in the interview as well. And I told her that, after June 2020, when we had the first COVID attack, anti-dumping investigations have seen an upward trend. There is a huge increase because the Chinese producers, South Korean, they are export-oriented producers in South Korea. Majority of them are export-oriented. They don't have local market. Then like Indonesia, Malaysia, especially China, when they opened up their factories, they had to produce more. And then if they have to produce more, they have to sell somewhere. The total international domestic demand has shrunk, but they had the capacities. So they have to produce in order to utilize the capacity, reduce their production cost. So what they have been doing for the last few months, that they are producing more and they are dumping more. So we have seen in a post-COVID time, much larger increase of anti-dumping investigations globally. Everywhere in the world, in Pakistan, in India, in many other jurisdictions, there are more investigations than before. Yes, it's true. Thank you very much. Thank you.